Welcome, everyone. I'm Paula Seitz with the Indiana Public Defender Council. Our topic for today is immigration consequences of criminal convictions, which I have to say is one of the most complicated areas of the law that I've encountered in my 30 years of this. Fortunately, our presenter for today is Maria Baldini Poderman, who is a frequent lecturer and nationally recognized authority on immigration consequences of crimes. She has authored Horn Books, is the upper of Immigration Law and Crimes, the leading national criminal immigration treatise, and is co-author of a Judge's Bench book on immigration law and criminal proceedings from the ABA. She assisted in writing IPDC's first ever immigration law manual and is an Illinois leading lawyer in immigration. She wrote Defending Non-Citizens in Illinois, Indiana, and Wisconsin, as well as Defending Non-Citizens in Minnesota Courts. A cum laude graduate from the University of Minnesota Law School, she later taught in their immigration clinic. She was the recipient of 2 National Association for Public Interest Law Equal Justice Fellowships focused on criminal immigration. The American Immigration Lawyers Association awarded Maria the Edith Lowenstein Award for excellence in advancing the practice of immigration law in 2010. She also speaks Spanish fluently. Please welcome Maria Baldini Poderman.
Thanks, Paula. I'm really glad to be here with you all today. And we're going to start talking about how the criminal dispositions may affect the immigrants and non-citizens that live in the state of Indiana. So to get started, we're going to go from 1996 when the law changed and up through the present. But to begin with, why should anyone who's a public defender or criminal defense attorney really care about what the immigration consequences are going to be for the non-citizens who live in the state of Indiana? Well, the U.S. Supreme Court decided in 2010 that this is a requirement and there's an affirmative duty on defense counsel to provide accurate advice to non-citizens about the immigration consequences of criminal convictions. In a case called Padilla versus Kentucky, the Supreme Court announced that deportation is a penalty, and particularly in light of the 1996 immigration legislative reforms. So under Padilla versus Kentucky, silence is no longer golden, and the duty is on the criminal defense attorney to investigate what the immigration consequences will be as a result of a plea or going to trial and loss at trial. So what standard applies? Well, it's the typical criminal standard under Strickland versus Washington for ineffective assistance of counsel claims. In Padilla, the court said where the immigration consequence is clear, the defense attorney must advise the non-citizen what the consequence will be. So how do we figure out what is clear versus unclear as far as the consequence goes? The first thing we need to do is to actually look at what the immigration statute says, and then look at what the criminal statute that has been charged says, and we look at the elements. So we're going to take a quick look here and see what the grounds of deportation are versus the grounds of inadmissibility. The grounds of deportability are found under 8 of the U.S. Code 1227. As you can see from the screen, it's quite easy. You can just build the section for the grounds of deportability, and the grounds of criminal deportation are found under 8 U.S.C. 1227 A2 and subsequent. So as a quick overview here, we have crimes involving moral turpitude that constitute a ground of deportability. We also have the aggravated felony ground, high-speed flight from an immigration checkpoint, failure to register as a sex offender under the federal code, and then a substance regarding pardons. Controlled substances also are listed, and one of the main that we'll be talking about a little later in the presentation, anyone who has been a drug abuser or drug addict after admitted to the United States, firearms offenses, some other grounds that deal with espionage, as well as export of certain types of computer equipment and other equipment. Domestic violence, stalking, child abuse are all grounds of deportation, as well as a protection order, even if there's not a conviction involved. Then we further move along other grounds related to security and terrorism, which are found here. And then there's a waiver for victims of domestic violence. For the grounds of inadmissibility, which are ways that the person can be kept from coming into the United States or obtaining status in the United States, those are under 8 U.S.C. 1182, specifically 1182A. So on the grounds of inadmissibility, we also have the crime involving moral turpitude and any offense relating to a controlled substance, as a controlled substance is defined in 21 U.S.C. Section 802. There's an exception which we'll talk about in greater detail for only crimes involving moral turpitude where it was committed as a juvenile or where it's something called a petty offense. We have multiple criminal convictions where the total time sentenced to confinement is 5 years or more. Controlled substance traffickers, which does not require an actual conviction. Prostitution, commercialized vice. And then there are also the money laundering grounds and security and terrorism grounds as well. We'll get into those in a little bit more detail a little later in the presentation. So initially, the best practice is do your research before you advise a non-citizen. And where after you've done all your research, the result is that it's unclear what the immigration consequence is going to be, then you may want to refer that out to an immigration attorney.
And I will just mention that we have a list of immigration attorneys, which includes Maria, on IPDC's expert database on our website.
Thanks, Paula. The other interesting part of the Padilla versus Kentucky decision was a discussion in the majority opinion that criminal defense counsel and prosecutors should consider the immigration consequences as part of the plea bargain process, and that there may be ways to creatively resolve the pending criminal case that won't result in the mandatory deportation of a non-citizen, and particularly long-term permanent residents or green card holders. Now, Indiana was actually ahead of the game. So starting back in 1994, the Indiana Court of Appeals had issued a decision called Williams versus State. And in that case, the Indiana Court of Appeals held that it was ineffective assistance of counsel to fail to advise a non-citizen defendant about the deportation consequences of a guilty plea under the Sixth Amendment of the Indiana Constitution, as well as under the Sixth Amendment of the U.S. Constitution. So the Padilla rule has actually been in effect in Indiana for now 21 years. The Indiana Supreme Court also upheld that ruling in a case called Segura versus State in 2001. And this was 9 years before the U.S. Supreme Court found and held in Padilla that the duty fell on the defense attorney to advise. And there was another case called Seal versus State. Now, the Indiana Court of Appeal and Court have issued additional decisions, but these are provided to you as some context of the rule that has actually been in effect in Indiana for over 2 decades. Facts that are to be considered under pre-Padilla case law included counsel's knowledge that the defendant was an alien or a non-citizen, whether or not the defendant was familiar with the consequences of the conviction, the severity of the criminal penal consequences, and the likely subsequent effects of deportation or other immigration consequences. Now, the Supreme Court, 3 years after it issued Padilla, issued another decision called Chidas versus U.S. And the Chidas case actually arose on a case out of Illinois. And it was the Northern District of Illinois decision that went to the Seventh Circuit, and then the Seventh Circuit case went up to the Supreme Court. So in Chidas, the Supreme Court held that the Padilla rule does not apply retroactively to pleas entered before March 31st of 2010, which was the date of issuance of Padilla. But In looking at a broad overview of where the states have gone post-Chidas, different state Supreme Courts have held under the state constitutions that Padilla does actually apply retroactively. So let's take a step back and we're going to run through kind of the scenario of how, as a criminal defense attorney, you should be analyzing your non-citizen defendant cases, or actually any case that walks into your office. Just because someone speaks English fluently does not actually indicate that the person is a U.S. citizen. They may have lived in the United States for 50 or 60 years when they become your client, and then suddenly be charged with an offense that could render them deported without any possible remedy to remain in the United States. So step one is your client a U.S. citizen? Step two, will a plea or admission of facts result in a, quote, conviction for a non-citizen client? 3, will a proposed disposition of your client's case render him deportable or inadmissible for immigration purposes? And for lawful permanent residents, will a conviction bar that person from naturalization or the ability to become a U.S. citizen in the future? And 4th, if the charge cannot get amended to avoid the immigration consequences, what arguments can be made at the sentencing stage to avoid an aggravated felony conviction? And alternately, if the person has already been convicted when they come in to see you, what are the possibilities for post-conviction relief? Now, to give the eagle's view of how this immigration system works, we're going to go through the different branches that are involved and how this actually plays out for your clients here in Indiana. So Congress enacts the legislation, as we all know. The executive branch implements the legislation enacted by Congress. Now, some of the documents that your clients may bring in to you at times will be INS-issued documents if they were in the United States on or before March 1st of 2003. So following the 9/11 terrorism attacks, the Homeland Security Act of 2002 was passed by Congress. Part of that act actually abolished the INS, which used to be in the U.S. Department of Justice, along with the Immigration Court functions. And it created a separate agency that is under the president. So the Department of Homeland Security and the Department of Justice are both federal agencies under the current president. The head of the Department of Homeland Security is Secretary Jeh Johnson. Then we have our heads of ICE and CBP and USCIS who are listed here. Chicago actually has jurisdiction over the offices in Indiana. So Chicago is the main field office for ICE, as well as USCIS and CBP. Here in Indianapolis, you all have a sub-office located in downtown Indianapolis, and that sub-office adjudicates applications for green cards, for temporary types of status in certain instances, as well as applications for naturalization or citizenship. Now, Lake County, Porter County, LaPorte County, and St. Joseph County are those non-citizens will end up dealing with the Chicago USCIS office. There are also CBP offices located in Evansville, Fort Wayne, and Indianapolis. And the sub-office for the Chicago ICE field office in Indianapolis is also located in downtown. Some of your clients may have had some contact when they were booked into the county jails or into the federal holding facilities with an ICE officer at the time of their book-in or shortly thereafter. As I mentioned before, we also have the Department of Justice. It's currently headed by Attorney General Lynch. And within the Department of Justice, we have the Executive Office for Immigration Review, also known as EOIR, but this is not the EOIR from Winnie the Pooh. We have the Immigration Courts system, and for cases that are covering non-citizens in Illinois, Indiana, and Wisconsin, all of those hearings are actually conducted in downtown Chicago at the Chicago Immigration Court. A decision from the Chicago Immigration Court can be appealed to the Board of Immigration Appeals, which is located in Falls Church, Virginia. All immigration court appeals go to Falls Church, Virginia, or the BIA as it's fondly known. Then the Office of General Counsel processes Freedom of Information Act requests. So if your client has previously had an immigration court hearing, a copy of his or her file can be obtained through the Office of General Counsel under a FOIA request. And for the EYR FOIA requests, those are generally processed in 4 to 8 weeks. Now, in comparison, to request a copy of what is known as the A file or the alien file from the Department of Homeland Security, there is also a process to file a Freedom of Information Act request through the National Records Center. Those FOIA requests can take anywhere from 4 weeks to 6 months to get the initial response. Within the Department of Justice, we also have the Office of Immigration Litigation, or known as OIL. And oftentimes, OIL attorneys will be brought into cases that are pending before the federal district courts in Indiana, as well as Chicago and Wisconsin. Most of the OIL attorneys are located in Washington, D.C., although there are OIL attorneys who are positioned or stationed in Chicago that will often assist in litigation as well. For those of you who practice federal criminal law, you may also find clients who are facing 1326 charges for illegal reentry after a prior deportation or other federal immigration and criminal charges. The U.S. Attorney's Office, of course, is involved in federal prosecutions at the trial court stage. Now, the Article III courts under the judicial branch interpret the immigration laws that are passed by Congress, determine their constitutionality, and apply them to individual cases. So within this system, we have the federal district courts, the federal circuit courts of appeals, and the Seventh Circuit has jurisdiction over all the cases that arise out of Illinois, Indiana, and Wisconsin. And then cases can then be petitioned under a writ for certiorari to the U.S. Supreme Court. With respect to the Board of Immigration Appeals, which again we just noted has jurisdiction over all the cases arising in the immigration courts, once the Board of Immigration Appeals issues a decision, then that decision can be reviewed by the Seventh Circuit Court of Appeals through what's called a petition for review. Now, as part of the 1996 reforms and some 2005 Real ID Act reforms, there are limits on what the federal courts of appeals can actually review. And oftentimes it involves the type of criminal charge that was brought. So the ability to review certain cases is limited, and it's a complicated area of law as well. So an appeal goes from the immigration court to the Board of Immigration Appeals to the Seventh Circuit, and then potentially up to the U.S. Supreme Court. Deportation is a penalty. So where did this term come from, and how has it evolved in our case law? Well, back in 2001, the U.S. Supreme Court first addressed some of the consequences of the 1996 overhauls of the immigration statute. So in a case called INS versus St. Cyr, the Supreme Court looked at and decided that for persons who had pled guilty to certain criminal offenses prior to April 24th of 1996, and they were long-term permanent residents, a waiver known as a 212C was still available. The Supreme Court said deportation is a penalty and plea bargains matter. So why was that important? It was important because in entering into a plea bargain, non-citizens, and particularly again long-term green card holders, did consider whether or not they were going to get deported and whether there was an opportunity for them to apply for this 212C waiver from deportation when they entered into their plea bargains. So the Supreme Court again looked at what is a plea bargain and why does it actually matter. For our U.S. citizen clients who are charged with crimes, most of the time the most important part of the plea bargain is to lessen or eliminate any time in jail or prison so that they can return and be with their families and keep their jobs. For non-citizens or permanent residents in particular, it means whether they can stay in the United States or not. So the Supreme Court held that despite the Anti-Terrorism and Effective Death Penalty Act of 1996 elimination for eligibility for most lawful permanent residents, that people could actually apply for this 212C waiver before the immigration judge or before the former Immigration Naturalization Service, or INS. In 2008, in a different case, The Supreme Court also looked at this issue that plea bargains matter and deportation is a penalty. So where you have statutory language with a right to reopen a case and to be able to move forward on a form of relief, it did matter in this context as well. In another case, the Supreme Court looked at the 212C issue again in a case called Judulong versus Holder. And this is a case that arose with a basis in the Administrative Procedures Act, as well as the constitutionality of a provision. And the Supreme Court rejected the Board of Immigration Appeals decision, which Matter of Blake had held that you had to have an exact match between the ground of deportability and the ground of inadmissibility to get a 212C waiver. And the Supreme Court said that that was arbitrary. It wasn't based on the law. And so as long as the person had pled guilty before September 30th of 96, when we had the overhaul of the entire Immigration Nationality Act, that person could apply for a 212C waiver. And as you can see, the Supreme Court overruled the 1st, the 3rd, the 5th, the 6th, the 7th, the 8th, the 9th, and the 11th Circuit Courts of Appeals published decisions. So the case Judulong versus Holder is an important case for immigration purposes on the relief side. For your clients who actually were green card holders and took a brief trip abroad and then were charged with being inadmissible or being prohibited from returning to the United States as a lawful permanent resident, the Supreme Court said as long as it was a brief trip abroad and you didn't commit any other criminal offense outside of the United States, that pre-1996 conviction cannot be held to bar you from being able to return to the United States. So in a case called Vartelis versus Holder, which was actually a pro se case that went to the U.S. Supreme Court, the Supreme Court again looked at what the consequences are and the issue of the plea bargain in deciding this case. So as you're coming up on permanent residents who are now being charged with criminal convictions and they have something in their past before September 30th of 1996, it's still going to be really important to get all of those records, because the immigration consequences will differ depending upon when the person was convicted and their current charge as well. So who is subject to these immigration consequences of criminal dispositions? Well, U.S. citizens are not subject to deportation or grounds of inadmissibility if they are citizens. The Immigration Nationality Act for immigration consequences applies to people who are not U.S. citizens. So who is a U.S. citizen? Generally, anyone who is born inside the United States is a U.S. citizen. A question often comes up, well, what about those people who are Puerto Ricans, who are born on the island down in the Caribbean? Well, after some legislation was passed back during World War II, Puerto Ricans who are born in Puerto Rico are actually U.S. citizens. So that is something to keep in mind as well. Now, acquisition and derivation of citizenship. This can be a little complicated, and there are actually charts available in different immigration treatises to help you out. After the Child Citizenship Act of 2000 went into effect on February 27th of 2001, the general rule of thumb here is going to be that if a person is a permanent resident and became a permanent resident before the age of 18, and their parent, being one parent, is or became a U.S. citizen before the age of 18, and that lawful permanent resident is residing in the United States, they are going to be a U.S. citizen. The issue may come up as far as who has physical custody, where there's a divorce or a separation. And these are points that, in order to determine whether or not your green card client may be a citizen, would be best looked at with the assistance of an immigration attorney. A non-immigrant visa holder, or what we call an NIV, is someone who has actually been admitted into the United States by the Department of Homeland Security for a temporary period. So some common non-immigrant visa holders are F1 students, J1 exchange visitors, for example, people who come in to work at Great America or at some of the resident camps like the Girl Scout Council here in central Indiana will bring in J1 exchange visitors to run their camp program. H1B, who are technical workers or have highly advanced education. H2B, who are brought in as seasonal agricultural workers. L1 workers, L1s are multi or international company executives, multinational executives who come in for a limited time period. And then for people who have also been considered to be undocumented or who have actually entered with permission but obtain a U visa based on being the victim of enumerated crimes and demonstrating that they've been harmed by the crimes and that they've cooperated with law enforcement, they are also deemed to be admitted to the United States. Now, those who are admitted at a port of entry will often have a small white I-94 card. Those who have been granted status will also have a receipt notice that evidences an I-94 card at the bottom of it. So we're going to take a look at a couple of different forms that you may come across when you start asking your client for proof of what their immigration status is. So this is the old-fashioned. This is a sample I-94 which your clients who prior to the CBP issuing these cards now or recording the information online, that they will have a passport or from a passport if they have the passport in which they entered. So some of the information I wanted to point out on this for evaluating their original entry and immigration status, their name is going to be found here on with their date of birth. Number here up at the top, the I-94 card number. This number is very useful if you decide to file a Freedom of Information Act request to obtain the rest of any immigration files document that they may have. Over here on the right, we have that they were admitted to the United States on September 3rd of 1991 in B2 or temporary visitor visa status, and that they were admitted until 10th of 1990. And up here at the top, the letters in the middle, WAS means that they were admitted at Washington Airport. If they were admitted in Chicago through either O'Hare or Midway would be CHI. Indianapolis would be IND. New York City would be NYC. So to an immigration attorney, this is going to be important information to have. For those who entered as well, they should have a stamp in their passport. So over here, you'll have the type of information that is available. It'll have the date of entries, and it looks like they entered July 11th, 2014 as an F1 status, the F and the 1 for student, and they were given, which is duration of status. There's actually a copy of a visa that was issued into their passport. So for an attorney to look at this or yourself to look, you would want to see what immigrant visa they came in on, where it was issued, the date of issuance, etc. Now, the USCIS notices that grant temporary immigrant visa status are going to have a period noted, unless it's a notice for an F1 student, which would be notice of duration of status. So as an example, people who come H-1B visas or who granted H-1B status in the United States are given a 3-year period. U visa actually for a 4-year period. This is a sample H-1B approval notice, and it's called the Form I-797. It'll have the person's name, and then up here, which is important to note, it's going to have the date which they were admitted to the United States and given permission to remain in the U.S. It will also have the date that a case was received. Oftentimes for someone, if a person is eligible for immigration benefits, we'll need to know what the date of the receipt of a visa petition was. And it'll have the part of the government that issued the notice as well noted below. A person who is granted an immigrant visa abroad to come into the United States is known as is going to be known as being admitted as an immigrant. They are going to then be allowed to reside in the U.S. as a lawful permanent resident or an LPR or what's called a green card holder. They will have an I-551 card or a resident alien card, as some of them are titled. Then someone who is a conditional resident has a 2-year green card based on marriage to a U.S. citizen. And that person is actually going to have to apply with another form to the government to take the conditions off their residency in order to obtain the full permanent resident card, which is valid for 10 years. So this is a sample card for a permanent resident, and this is a current version of a permanent resident card. So it'll have the person's name up here, and then their alien registration number. Over here where it says category, that's going to be important to determine how they were granted permanent residence. So here it says RE8. It looks like this person originally entered as a refugee and was granted a green card based on refugee status. It'll have the country of birth, date of birth, date the card expires, and then below which they had permanent resident. Full information for you to have as well as that you confer with. This is an older version of the card. Again, we've got the person's name, their A number, date of birth, category, and again, upon which they obtain their residency, country of origin or country of birth, the date the card expires, and how long that person's been a resident. This number that's circled over here, SE, has to do with part of the government that issued it or approved the petition. Now, this is some other
Maria, I understand that's a green card, but I can't help noticing that it's pink.
You're right, Paula, it is pink. So this is one of the older green cards. It's a 10-year green card that was issued, and that was issued before 1990. So this is a date here of expiration. This would be the person's alien registration number, their birth, their name, and their fingerprint. We're going to go now to another example of a really old green card. And this one wasn't even green either. This is beige. So on the resident alien card here, what's important to note, we've got the person's name, their date of birth, their alien registration number. And then on the front of the card, we also know where this person was as a permanent resident. LOS is Los Angeles. Then we also have the class of entry, which tells us how they were admitted to the U.S., so the basis. So signature used to actually be on the front of the card as their fingerprint. For this resident alien card, we also want to know when the person was admitted as a permanent resident. So April 3rd of 1980 is the date of admission. And if you're consulting with an immigration attorney, the immigration attorney is going to want to see this card because the front of the card doesn't have that information on it. So it's really important to get a copy of both the front and the back of the card if you have a client whose green card was issued before 1990, as this one obviously was. As someone who has been recognized by the U.S. government outside of the U.S. and then been allowed to come to the United States and be admitted as a refugee. An asylee is someone who is actually granted asylum by the USCIS Asylum Office or by an immigration judge. An asylee will have a written decision, granting asylee status, as well as an I-94 card. And these are going to be documents you want to ask for. For a refugee, they will have an I-94 card evidence that they have been admitted as a refugee.
Recently received a letter from a prison who is serving a sentence for a rape conviction. He is a refugee from Myanmar, and he's concerned deportation deportation after his sentence. Tell me about that.
Well, I can tell refugee status cannot be terminated except where someone has committed fraud in the refugee process. So this person can be subject to the grounds of deportability for having been convicted of an aggravated felony, which we'll get into in a little bit what constitutes an aggravated felony, but rape is one of those on the list. To compare termination of refugees, however, with termination of asylees, someone who has been granted asylum in the United States can have the asylee status terminated by the USCIS if they have been convicted of an aggravated felony. So there is a difference in what the grounds of deportability are and how it affects the person's actual status. Now, an intent to terminate asylee status can be reviewed by an immigration judge when that person, if they want to see the immigration judge to contest the termination of their asylee status. So there is actually more protection offered to someone who is admitted as a refugee, having been processed overseas as a refugee, than someone who was granted asylum within the United States.
Thank you very much.
Sure, Paula. Temporary protected status was created by Congress in 1990 through the Immigration and the Immigration Act of 1990. Temporary protected status is a status that is designated for nationals of a country by the Attorney General for specific periods of time. It can be renewed. Some of the countries for which temporary protected status currently exists include Honduras and El Salvador, as well as Syria and Yemen. On the USCIS's web, which is uscis.gov, you can look over here and scroll down and then go to humanitarian, click on humanitarian. And there's another link that talks about temporary protected status and then what are designated for TPS. And it includes the dates of designation. So for example, as you can see, El Salvador designated March 9th of 2001, and it's still currently designated. If someone came from El Salvador after March 9th of 2001, they qualify for TPS. And this is important as well. For Honduras, as we see, January of 1999 is the qualifying date. Liberia was designated in 2015. It previously had been designated and then had to in place. Sierra Leone is currently designated, Somalia, Sudan, South Sudan, Syria, and Yemen. So this list is updated, and again, it's all the information is available on uscis.gov under the humanitarian link. Another really important term to understand is something called Deferred Action for Childhood Arrivals. This provision is not found in the Immigration and Nationality Act, but rather it is an executive action program that was created on June 15th of 2012 by President Obama and is intended to grant a deferred action status, which allows a non-citizen who is brought into the United States at a young age to remain in the U.S. temporarily. DACA, as it is currently known, is available, and the requirements are listed on the USCIS site. So we're going to take a look now at what the requirements are, because for many individuals who are in their late teens or early 20s or late 20s, the ability to obtain an Indiana driver's license depends upon their ability to prove that they're in the country. And so DACA is one that they can obtain a work permit from the USCIS and then provide that to the Indiana Bureau of Motor Vehicles in order to obtain a driver's license and avoid the consequences that can arise from multiple charges of driving without a license and Indiana Code's habitual offender provision. Returning now to the IS's website, we have on the page here a link on the right-hand side, Consideration for Deferred Childhood Arrivals Process. So the page is updated frequently, USCIS, and there are different provisions. But what I want to draw your attention to now is down on the page. So these are the guidelines to qualify for DACA. The person had to have been under the age of 31 on June 15th of 2012, came to the U.S. being age 6, has continuously resided in the U.S. since June 5th, 2007 to the present, is physically present in the U.S. on June 15, 2012, and at the time of the application for deferred action, USCIS, was out of status or had no loss on June 15th of 2012, is in school or has a high school diploma or GED certificate or is working toward those, or is an honorary discharge veteran of the Coast Guard or any of the armed forces of the United States, and has not been convicted of felony, significant misdemeanor, or other misdemeanors, and otherwise is not a threat to national security or public safety. Now, you may, what is a significant misdemeanor, and where did that term come from? Well, that term is not contained anywhere in the Immigration and Nationality Act, and so the issue of how do you determine what it is actually contained from here on the web page. So a section here called National Public Safety Guidelines, and when it says that the person is not going to be considered for DACA, it defines what a felony is, which is kind of our typical definition of felony. And then significant misdemeanor is a misdemeanor defined by federal law, specific to the maximum term of imprisonment is 1 or less, but more than 5 days. This is important. Some states define misdemeanors as being subject to imprisonment of up to 2 years. So that seems to how Indiana misdemeanor, but because you have clients who may have just resided solely in Indiana since they arrived, you need to look at what their priors are as well. And then there's a list of offenses that the government are going to be called significant misdemeanors, regardless of how much time is imposed. Any offense of domestic violence, sexual abuse or exploitation, burglary, unlawful possession or use of a firearm, drug or trafficking, or one you may often see among your clients is driving under the influence. So that OWI charge here in Indiana. And then if the offense doesn't fall on this specific list above, then the person was sentenced to serve more than 90 days in jail. And it has time that is actually served in custody and not a suspended jail sentence. So again, this is kind of a very technical misdemeanor definition that again does not appear in the code anywhere, but it will disqualify someone from being eligible for the DACA program. Then we have what are called non-significant misdemeanors, which are also defined, including someone who is sentenced to serve 90 days or less in jail. For clients who have employment authorization documents or work permits, they may have it because they have an application for adjustment of status to get a green card or become a permanent resident. They may also have it because they have an application pending before the immigration court for what's called non-permanent cancellation removal or tenure cancellation, or an application for cancellation removal under the Violence Against Women's Act. Then we have the DACA that we discussed, TPS, some asylum applicants whose applications have been pending more than 150 days, F1 students may also have a work permit if they've been allowed to obtain employment based on need. U visa work authorizations are going to be valid for 4 years, as I mentioned earlier. Orders of supervision and deferred action status. And this deferred action status is different than a deferred action status. Here we're going to run through some sample employment authorization documents that your clients may have, and I'm going to point out a couple of things on this as well, which is helpful to deciding and determining what their status is. Okay, so this is one of the more current versions of what the employment authorization or work permit looks like. You'll have the alien registration number again, the category here. So this one is based on an application for adjustment of status, a C09, and the country of birth, date of birth, and when the card is valid. So nobody would actually have an employment authorization that is valid for 31 years. This gives you an idea of what the card looks like. Now, some of the older work permit cards or employment authorization documents will often look like this. Again, we've got the old INS labeled here, the A number, the signature, the fingerprint. So it's kind of looking like the green cards, the older versions of the green cards that we saw. Then they'll have the category in which the employment authorization was granted. And then the card will be valid from certain date to date. Okay, where does all this Immigration Nationality Act arise from? Well, the current version of the code was actually based on the Immigration and Nationality Act that was passed in 1952 after World War II. The Pre-Illegal Immigration Reform and Immigrant Responsibility Act, or known as IRA-IRA, included terms of exclusion, deportation, and orders to show cause. So before the law that was passed on September 30th, 1996, IRA-IRA, went into effect on April 1, 1997, non-citizens were placed in exclusion proceedings, meaning they were knocking at the door, they were asking to come in. Typically, they were taken into custody or appeared and asked to be admitted to the U.S. at an airport or a border land entry. So for those of you who have never been to the southern border, the immigration judges actually used to hold court for exclusion proceedings on the international bridges connecting Mexico and the United States. And so people who asked to come in, who the Border Patrol officers initially determined were not admissible or were to be excluded from the U.S., could ask for an immigration judge to review whether they were actually excludable from the United States. Deportation proceedings were instituted for anyone who the Immigration Service, the INS, Naturalization Service, found in the United States. And so these people had to physically cross into the U.S. to be put in the deportation proceedings. Orders to show cause were the terminology that was used to place someone into a deportation proceeding. It's a document similar to a charging information, an indictment, or a complaint in the criminal proceeding. Now, post-IRA-IRA, we have new terms, which can be a little confusing. So IRA-IRA combined the exclusion proceedings and deportation proceedings into a new ground just called removability. But the new removability grounds are divided again into grounds under which someone can be kicked out of the country or deported from the country versus being found inadmissible or deemed to be knocking door. So as you're reading the case law, it may seem a little confusing, but again, the grounds that constitute the reasons to kick someone out or to deport them are found under 8 U.S.C. section 1227, and the grounds of inadmissibility are found under 8 U.S.C. 1182. And those were the sections of the Immigration Nationality Act that we looked at earlier. The new charging document is called a notice to appear, or an NTA. Now, for those of you who may not know that the immigration mechanism actually works to send people out of the country, in 2007, we had 291,060 people who were physically deported. And as you can see from this slide, the numbers continue to increase. And in fiscal year 2012, there was an all-time high of 400,849 people who were physically deported. In fiscal year 2012, on June 16, 2012, is also when President Obama announced a program. And as a result of DACA and a greater use called prosecutorial discretion, numbers have increased in the number of people physically removed from the United States. In the total numbers of ICE removals are also available at the ICE's website, and you have the link here. And back in 2010, when the deportation had been evidently ramped up, there was actually a Post article that broke saying that there were actually quotas that were set up for ICE officers to pick up people and physically remove them as part of their performance evaluation. That's how many people they could get removed. Now, while the ICE resources were increased by Congress, the immigration court resources were not. And so there's been a resulting bottleneck in how quickly someone who is not in immigration custody will actually have their hearing concluded and the case decided. So there are approximately 260 immigration judges in the country. And every year, the number of new cases that get filed has typically gone up. So there were, in fiscal year 2014, over 306,000 new cases filed with the immigration. And even the number of immigration judges in total, 248,000 cases or matters. And from that, the Board of Immigration Appeals, however, received only a fraction of appeals from those decisions. In the last 5 years, Mexico has remained the top country of national for number of cases completed by the immigration court, and it's been the other top four countries have been Guatemala, El Salvador, and Honduras, and China. And as we all know, the violence in El Salvador, Honduras, and Mexico has continued to increase, and fleeing persecution, torture, and the drastic violence in those countries continue to seek refuge. So as a result of the number of mothers and children, as well as other people fleeing the violence, the number of cases of asylum applications has increased, as well as the detention of mothers and children, and information is available. But it's also backlogged the court dockets in Chicago in particular. So due to retirement of immigration judges in Chicago, there's currently a major backlog. So if the non-client that you're representing is not in custody and does not have an ICE hold but is placed in proceedings, it can take anywhere from a year to 4 to 5 years for a case to be completed. Now, we're expecting to get 4 new immigration judges in Chicago sometime in 2016, so the frames may move up. As we discussed earlier, appeals from the BIA decisions go to the Federal Circuit Courts of Appeals as petitions for review, and then up to the Supreme Court as petitions for writs of certiorari. Now, what did the 1996 reforms to the Immigration and Nationality Act do? Well, just a minute ago, they eliminated the deportation and exclusion proceedings and created these new removal proceedings. It also eliminated 212C waivers and suspension of deportations for permanent residents and non-permanent residents, and created very limited forms of relief for permanent resident cancellation and your non-permanent resident cancellation. It amended the definition of a conviction, and it expanded the grounds of deportability, why someone can be kicked out of the country. In particular, before 1996 IRA reform, a person could be deported from the United States for a crime involving moral turpitude if there actually had been a 1-year sentence or 365 days of jail time imposed as part of the sentencing order. And now that has been reduced to a 1-year maximum possible term of imprisonment. And that does impact on basically creating a disparity between what the consequences of a misdemeanor in Indiana are going to be for a crime involving moral turpitude versus a misdemeanor over in Illinois or Wisconsin, which are the 3 states within the Seventh Circuit's jurisdiction. It expanded the definition of an aggravated felony to include 50 categories of offenses, including many misdemeanors. And again, with a misdemeanor in Indiana being sentenciable up to 365 days in prison, that has a drastic impact on who is going to be considered to be convicted of an aggravated felony. It created a new ground for deportability, or a reason why you could be kicked out, to include a crime of domestic violence, stalking, child abuse, and child abandonment. That provision went into effect on September 30th of 1996. Also, this other ground involving a finding that there has been a violation of a domestic protection order, either by a civil court or a criminal court, went into effect on September 30th of 96. This provision does not require a conviction. It merely requires that the person be found to have violated in order for protection that is related back to a domestic violence ground. It includes false claims to U.S. citizenship and voting. Forms restricted what waivers can be granted for a misrepresentation and a false claim to citizenship. That went into effect September 30th of 1996. It restricted what's called a criminal waiver, called a 212H waiver, for a permanent resident who's been convicted of a marijuana offense, as well as crimes involving moral turpitude, to eliminate the ability, except in certain circumstances, to apply if the conviction is deemed to be an aggravated felony. And it also created unlawful presence, and permanent bars to obtaining permanent resident status, even if the person has U.S. citizen parents or spouse or children. And this unlawful presence bar is one reason why some of your clients who are married to U.S. citizens and have multiple U.S. citizen children may not be able to go to Mexico or another country to obtain their green card or their immigrant status. IRA also created new expedited removal processes at ports of entry for people who are attempting to seek refuge in the United States or who attempt to come into the U.S. without the proper documents. And for criminal cases, this is a particular issue, especially for clients who are in custody for a criminal arrest and end up with an aggravated felony conviction. In those instances, if the person is not a refugee, an asylee, or a permanent resident, an ICE officer can actually issue a final administrative order of removal against the person without ever giving the individual the right to have a hearing before an immigration judge. It also eliminates the ability to obtain discretionary relief, including status, if the person were otherwise eligible based on marriage to a U.S. citizen, and discretionary relief that the person may qualify, which includes asylum. So this provision is found under 8 U.S.C. 1228B as in boy. If your client is served with a notice of intent to issue a final administrative removal order, there is a limited period of 13 days in which to respond to the ICE office who issued it, and the response has to be in writing. So if you come upon that situation, you'll need to move quickly, get an immigration attorney involved if you feel that this is not something you can handle. We also have stipulated removal orders, and stipulated removal orders are where an ICE officer will visit a person who is in the county jail or in the federal prison facility. They have a permanent resident status, and the officer will present a motion that they ask the person to sign, and saying that they agree that they're deportable, they agree that they are giving up their permanent residence, and ask the immigration judge to enter an order of removal against them so that they don't end up actually going to an immigration proceeding before a judge. Now, in reports that have been done, over 85% of all removals of non-citizens from the U.S. occur through these final administrative removal orders, the expedited removal orders, and the stipulated removal orders. So as you can tell, a very small percentage of people actually ever get to an immigration judge. for hearing. We also have now what are called judicial removal orders that can be entered by a federal district court in criminal proceeding. We also have what is called reinstatement of removal, so where someone has been ordered excluded, deported, or removed previously, is physically out of the United States, and then decides to return to the US. That prior order can be reinstated, and that person will be sent back unless they have a claim to a fear of probable persecution or torture in their home country. For those of you who do the criminal defense work and deal with charges under 8 U.S.C. 1326 for illegal reentry, the Ninth Circuit case law is very prolific on what constitutes the right to challenge the reinstatement provision. The Seventh Circuit case law is not as favorable, although these cases can be taken up to the Seventh Circuit to try to move the precedent in a different direction. There was also a creation of a credible fear and a reasonable fear process for people who fear persecution or torture. The credible fear applies to people who do not have prior removals and who do not have aggravated felony convictions. The reasonable fear process applies to those who do. The visa waiver program was expanded, and as we all know, the visa waiver program is being reviewed by Congress currently in light of some recent issues that have arisen. And the 1996 law also created restrictions on what the circuit courts of appeals and the Supreme Court can review for final orders of removal. Another important point is mandatory detention under 8 U.S.C. section 1226C. What mandatory detention means is that as far as the immigration removal process goes, the person will not qualify to be granted a bond by an immigration judge. Who falls under this? Anyone who has been arrested and convicted on or after October of 1998 and is inadmissible for a crime listed under USC 1182A2. And as a reminder, those are crimes involving moral turpitude, as well as a single possession of marijuana, 2 grams, or possession of drug paraphernalia relating to marijuana or any other controlled substance. And if the person is deportable under 8 U.S.C. 1227A2, and for this one, if it's a single crime involving moral turpitude, a 1-year term of imprisonment or 1-year jail has been imposed. It does not matter whether the person actually serves that 1 year, it's just that it has been imposed. Or if the person has been convicted of multiple crimes involving moral turpitude, or the person has been convicted of an aggravated felony. So, to give you an idea of what might be an aggravated felony under Indiana Code, a conviction for misdemeanor conversion with a 365-day jail sentence that is imposed but suspended completing probation of a year, that would be deemed to be an aggravated felony, even though it's a misdemeanor retail type offense. It also includes any drug offense, any firearms offense, and then the miscellaneous offenses involving security grounds. Or if the person is deemed to be inadmissible or deportable for security and terrorism grounds. And that, of course, makes sense. Okay, so how do we actually determine whether an offense renders a person deportable, inadmissible, or barred from naturalization? The U.S. Supreme Court addressed the categorical approach in 2004 in a case involving a drunk driving conviction. And so the Supreme Court then laid out that we have the categorical approach and that applies to determine whether something is an aggravated felony or not. And under the categorical approach, we need to examine the elements and the nature of the offense, not what the facts of the offense were. And so in order to determine what the elements are, you actually need to obtain the code that was in effect at the time the person committed the offense. And as we all know, there's a new code now in effect here in Indiana as of July 1, 2014. So you do need to obtain the older versions of the code if your client has any prior charges or convictions from Indiana. Other states have also amended their criminal codes, so it's not quite as easy as just throwing in the code citation and Googling it. You need to make sure you've got the right section of the code in effect for the year that the person committed the offense. And then we look to what the generic elements of the statute are under which the person was convicted. So in 2006, the Supreme Court went further in looking at the categorical approach, but this time in looking at what it was deemed to be a possession of a controlled substance offense in a case called Lopez versus Gonzalez. And as we all know, states define offenses differently for possession offenses. So to give you an example, in North Dakota, a possession offense of 30 grams of marijuana is deemed to be a state felony offense. Here in Indiana, it's deemed to be a misdemeanor offense, as it is over in Illinois and Wisconsin. So under a Board of Immigration Appeals decision, the board had held that a state felony possession offense was a federal felony and therefore a drug trafficking offense. And the Supreme Court basically said no. If you have a state felony conviction for simple possession of a controlled substance, it is not an aggravated felony offense. There was an exception for possession of 5 grams or more of crack cocaine. But at this point, most of the case law has been pretty clear as far as what is a simple possession. Now, there was a second round of what constitutes a state felony and the aggravated felony offense. And this came up in a case that arose out of a removal case in Chicago, Carachuri-Rosendo versus Holder. So under the federal law, where a person has been previously convicted of a simple possession offense and notice an opportunity to challenge the fact that the prior conviction are not provided as required under federal law or a similar state provision, then a second or subsequent conviction is not a federal felony and is therefore not an aggravated felony for purposes of immigration law. And this was a very important case as well. So basically, the Supreme Court is saying you need to look to what the federal definition of a felony is for possession of a controlled substance, and if the state law categorically doesn't match it, then it's not going to be deemed to be a federal felony or an aggravated felony for purposes of the drug trafficking provision of the aggravated felony definition. In 2009, in a case called Flores-Figueroa versus Holder, and this case involved the raids over in Iowa, the meatpacking plants, if you all recall that. So the, excuse me, the Supreme Court said in this particular one, where people had used false identifications to obtain employment in the meatpacking plants and had violated federal law, the government or the prosecutor has to prove that the criminal actually knew that the identification belonged to an actual person in order for it to be deemed to be a conviction. The second case in 2009 that had to do with the felony definition for fraud or deceit. And the Supreme Court said that under the categorical approach, again, you look to the elements of the charged offense. And the court said there is one issue that you can actually look beyond the elements of the statute, and that is to determine the amount of loss for purposes of the aggravated felony definition of USC 11A43MI. And so the court can look to documents in the record, including sentence report or pre-sentence investigation. And so for those of you who are dealing with cases where the person has been charged with a criminal offense involving fraud or deceit and the loss to the victim is $10,000 or greater, you may want to discuss with the prosecution a way to reduce the amount of loss that is recorded in the criminal court file so that the person can pay back part of what is deemed loss and to avoid an aggravated felony conviction. The Supreme Court again took up the issue of what constitutes a drug trafficking offense and the categorical approach 2 years ago in a case called Moncrief versus Holder. And in Moncrief, the court said again, the categorical approach applies, and we look to what is the minimum conduct that is required in order to be convicted. So this case involved a Georgia statute that is actually quite similar to the statute in effect in Indiana as well as in Illinois for delivery of marijuana and possession with intent. And so in this particular case, minimum conduct under Georgia law involved a state criminal statute that included social sharing of a small amount of marijuana, and there was no requirement of remuneration in order to have the person convicted. Well, Illinois has a similar provision, as does Indiana. So one of the things that in looking at state drug offenses that we need to analyze is what do the jury instructions require and what have the courts held to be the elements of the offense. So why does this work as it does? Because under the federal statute, the sharing of a small amount of marijuana with remuneration is not a federal felony. It is deemed to be a federal misdemeanor. And again, if it's a federal misdemeanor offense, then it is not a federal felony for purposes of the Controlled Substances Act and is therefore not an aggravated felony. So does this actually work in reality in immigration court? And under the Illinois codes, the ILCS 550/5, it is any person knowingly to manufacture, deliver, or possess with intent to deliver, manufacture, or deliver. Any person who violates this section to not more than 5 grams of substance containing cannabis to have a Class B misdemeanor, and then it goes on to additional grounds. Well, nowhere within this require remuneration. And when I reviewed the jury instruction case law of Illinois, a recent case of a long-term permanent that I had a detained immigration court proceeding, it was clear that the instructions did not remuneration, and in fact, as part of the sentencing process and the sentencing provisions, the court could consider as an element whether remuneration was actually in as a sentencing factor. And judge that it was therefore because the element did not include remuneration, my client had not been convicted of a felony, and she was eligible to apply for a waiver to retain her permanent residence in the United States. Ultimately, the case was granted. So this is an example of what's a very powerful tool and why we need to look at jury instructions as well as case law to determine whether or not there is a consequence for a particular charge or decision. Okay, so in Moncrief again, illicit trafficking is a generic crime, so we have to look at how that offense is prescribed under Controlled Substances Act, being the Federal Substances Act, and the offense to constitute a federal felony under the Federal Controlled Substances Act for the conduct. Another is called DeComp U.S. in 2013. The court said the categorical approach again focuses on the elements of the crime, and you do not get to go to what is called the modified categorical approach, which lets you look at the actual record of conviction, unless the statute has alternative elements, meaning there are different ways to commit the offense. So this gets us into what is known as divisible versus indivisible statutes. This can be a little confusing, but we want to make this as clear as we can. So what the court said is that if you have a statute that has an indivisible set of elements, the court does not get to go to the modified categorical approach. So indivisible, meaning you have multiple ways to commit the crime and they're separated by commas, not by subsections. So let's take a look at what is going to be considered to be a Okay, so under the Indiana Code 35-45 with disorderly conduct. And this is an example of a divisible statute because we have actual subsections that are broken out. We have subsection A, purposely, knowingly, or intentionally. 1, engages in tumultuous conduct. 2, makes unreasonable noise and continues to doing up. Or 3, disrupts lawful assembly, commits disorder to be misdemeanor. Then section B, which defines it, becomes a felony. So let's go here to say for the moment. There are 3 different mens reas: reckless, knowingly, intentionally. So the statute is actually looked at to be, you look at what the minimum conduct is. So conduct for the mens rea is going to be recklessness. Section 1 engages in fighting or other tumultuous conduct. So look at what is the minimum conduct required in order to be looking at jury instructions and case law as well. Because we're in the middle. Under subsection 2, we have makes unreasonable noise and continues to do so after being asked to stop. There's one way to commit the offense under this, as far as the elements go. Subsection 3 disrupts a lawful assembly of persons. Hopefully this gives you an idea of what we're considering to be divisible versus indivisible. So in DeCamp, the Supreme Court said where the statute is overly broad or it's missing an element, the elements don't match the elements of the generic offense, and therefore the modified categorical approach cannot be applied to find missing elements or determine a factual basis. And this, again, is just really important. It comes down to looking at the elements of the statute, figuring out what those are. If it's a divisible statute, an indivisible statute, and then determining whether or not there is going to be a consequence. It's not as clear on the face as one might think. Okay, and then the Supreme Court emphasized the jury instructions that record can determine which element was proven and use law. Now, the issue that's currently pending at the Supreme Court, an oral argument was held at the beginning of November, is in a case called Luna Torres versus Lynch. It has to do with the aggravated felony ground, where you have language in the aggravated felony definition that says that the state offense is, quote, described in a federal statute, but the federal statute actually includes the interstate commerce element that the state statute lacks. And so is this case in particular involved in arson conviction? Previously, the Seventh Circuit had decided another case called Negrete Rodriguez, in which the interstate commerce element was missing from the unlawful possession of a firearm offense. But there were other provisions within Indiana law and Illinois law where the interstate element was present involving a firearm offense. The Seventh Circuit had ruled negatively. So this is an important case to watch, as a decision is expected by June 30th of 2016. Especially for those of you who have clients who are charged with state offenses of the interstate element in it. The Supreme Court, for a fourth time or fifth time coming along here, took up another drug case, and this one involved drug paraphernalia. And under the Kansas statute, the person was charged up and pled guilty to possession of drug paraphernalia, which actually ended up being a sock. The non-citizen in this case was a permanent resident who was a math professor at a university who had a couple of pills in his sock. Instead of pleading guilty to the pills, he pled to the sock. And it's actually kind of an interesting oral argument if you like to look at oral argument transcripts from the Supreme Court. Now, what the Supreme Court said is you need to compare the state-controlled substances list to the federal controlled substances list. And if the state-controlled substances list is broader than the federal controlled substance list, then the person is not going to be deemed deportable for a drug paraphernalia conviction because it doesn't relate to the controlled substances list. So this is a good decision to take a look at, and it does involve comparing the controlled state substances list at the time of the commission of the offense against the federal controlled substances list in effect on the date of the commission of the offense. I know that most of us aren't necessarily chemists in our background. I know I'm not. But it is a possible defense for someone who has a prior conviction for possession of paraphernalia. Okay. Now, another area of law that has been rapidly evolving at the U.S. Supreme Court level involves what is considered to be a crime of violence. And there are two provisions that come into play. One is the residual clause under the Armed Career Criminal Act. And on June 26th of this year, the U.S. Supreme Court held that the residual clause that defines a crime of violence that, quote, otherwise involves conduct that presents a serious potential risk of physical injury to another, vagueness. The Ninth Circuit then followed the Supreme Court Johnson case and held that the definition of a crime of violence under 18 U.S.C. 16b was also void for vagueness. And this has great significance for persons who are charged up with being deportable for an aggravated felony under C 1101-43 F as in Frank, or for a crime in domestic violence, USC 1227A2I, because 18 USC section 16 is specifically listed in both of these statutory sections. So while the Ninth Circuit case is only binding on cases arising within the jurisdiction of the Ninth Circuit, practitioners are raising the argument already within the jurisdiction of the Seventh Circuit to say that someone who's been convicted of a crime of violence and has been as a felony offense, which does not actually involve an element of the use of force or attempted use of force or threatened use of force against person or property, should not be found to be deportable for an aggravated felony offense or as a crime of domestic violence. So let's take a quick look at 18 U.S.C. section 16A and B. So, crime of the grounds of deportability for involving domestic, we can see right here that 16 of Title 8 of the U.S. Code specifically referenced in the Immigration Nationality Act. Likewise, the term aggravated felony at 8 U.S.C. A43 F as in Frank, again, 18 U.S.C. section 16 is specifically referenced. So the grounds here, whether or not a crime is going to be deemed to be a deportable offense, is a very emerging area of the law at this time. And you're best advised to definitely review what the case law is prior to the entry of a plea by your non-citizen defendant. In this next section, Paula and I are going to be going back and forth a little bit more as we run through what the steps are on doing a PDL these days. So again, step one, is your client a U.S. citizen? will plea or acts result in a, quote, conviction for your non-citizen client. 3, proposed disposition case render her deportable or inadmissible for immigration purposes. And 4, if the charge cannot be amended to avoid immigration consequences, what arguments can be made at the stage? Or term conviction means, with respect to an alien, a formal judgment of guilt of the alien entered by a court, or if adjudication of guilt has been withheld, where 1, a judge has found the alien guilty, or the alien has entered guilty or nolo conte, or has admitted sufficient facts to warrant a guilt, and the 2, the judge has ordered some form of punishment, penalty, or restraint on the alien's liberty to be imposed. So this is fairly significant. So where adjudication of guilt has been withheld, you have to have both prongs met. So you have to have a finding of guilt or plea of guilt or nolo contendere, known as no contest, or the person has to have admitted sufficient facts to warrant a finding of guilt, and you have to have an order involving some punishment, penalty, or restraint on an alien's liberty to be imposed. So let's stop for just a moment and take a look at what does it mean to have admitted sufficient facts to warrant a finding. This means that on the record before the court, the non-citizen defendant has stipulated to facts in the police report that may be attached to the criminal complaint or information. And this is a common procedure I have seen out of cases involving Wisconsin convictions or dispositions. And so it's really important, especially if you are dealing with what's called a deferred execution or continuance, to look and see what is being admitted to occurred, especially if your client is going to end up do some type of classes or restraint on liberty, to pay a fine, to make a contribution to a police fund, fraternal order, etc. But under the withholding of adjudication of guilt, if both of these prongs are met, a non-citizen will have a conviction. On the other hand, if one of these 2 prongs is not met, then there will not be a conviction for purposes of deportability. Okay? And the grounds of inadmissibility are a little broader, but let's right now deal with the definition from grounds of deportability. Okay. You have to look at the criminal court record really carefully. But if you're in the plea stage, this is an opportunity where you may be able to avoid immigration consequences for your non-citizen defendant. For example, entering into an agreement for a deferred prosecution, where the agreement does not go into the court file, but the agreement remains in the process file, and the non-citizen pleads not guilty at the criminal court hearing, and the case is merely continued while the person does classes or makes restitution or does something else that would otherwise be penalty, punishment, or restraint on liberty, will not end up with an immigration conviction. Okay. Now, what is the term punishment, penalty, restraint on liberty? It's been really pretty broadly defined to include incarceration, probation, fines, restitution, a rehab program, work release, revocation or suspension of a driver's license, deprivation of non-essential services or privileges, or performing community service. Costs, surcharges, and other assessments also have been deemed to fall under the term punishment, penalty, or restraint on liberty. And there's cases here that are cited, matter of Oscock and matter of Cabrera. Now, what is the definition of a term of imprisonment of sentence mean? Well, for immigration purposes, this is again under 8 U.S.C. 1101A48 and boy. It includes the period of incarceration or confinement by a court of law, regardless of any suspension of the imposition or execution of that imprisonment, the imprisonment or sentence in whole or in part. So when an trial court imposes 385 days in the county jail but suspends it pending completion of probation, that is deemed to be a 365-day term of imprisonment. Okay, a new case that just came out, in fact, this week, the matter of Calvillo Garcia, and it was published by the Board of Immigration Appeals, specifically defined a term of confinement in a substance abuse treatment facility which is imposed as a condition of probation. The Texas Penal Code was deemed to be a term of confinement for purposes of the crime of violence definition and an aggravated felony. So this is a really important point to note. So if the sentencing order is going to include for drug treatment, that is now going to be a sentence assignment, and then therefore can impose an aggravated felony consequence on a non-citizen. When we're dealing with the term sentence here within the definition, we're looking at jail time. So we're not what's actually been under this part of the definition. We're not considering probation a term of imprisonment by any means. Probation is a term of imprisonment. So in the example that we just talked about, 365 days of jail time and it's suspended pending completion of probation, that probation period could be more than 365 days. It could be 3 years of probation. The amount of probation is not going to matter. What matters is that 365 days to jail. If that's knocked down to being a 364-day sentence for the aggravated felony definition, where it matters if it's 65 days, a 364-day sentence is not going to get the same consequence. So a lot of state codes had previously what we called indeterminate sentences. Well, the indeterminate sentence is actually the maximum that was hung over the person's. They didn't end up serving that much, but the length of the indeterminate imposed is going to be the sentence of confinement for immigration purposes. And this does impact on purposes of eligibility of withholding of removal for people who fear probable persecution in the home country. And where you have multiple or concurrent sentences that are imposed, you look at what the longest sentence is of the two concurrent sentences, or the 3 or 4 or 5. Where someone has consecutive sentences imposed and it's an aggravated felony for each of those sentences, then we add it up, and if it's 5 years or more, the person is barred from withholding of removal.
You've mentioned now that a sentence in 64 days or can make a difference when that is.
Sure, Paula. So when we look at the definition of an aggravated felony under 11A40, up on the screen you'll get, example, there are provisions. There is no specific term of imprisonment imposed that will render it an aggravated felony. For example, subsection A, murder, rape, or sexual abuse, doesn't have a specific imprisonment requirement for it to be. The same with subsection B, that traffic controlled substance traffic crime. However, when we get down to subsection F, as in Frank, defined under section 16 of 18 code, for which the imprisonment is 1 year. The term of imprisonment imposed by a court, 64 days, is not going to bring the definition of a crime of violence and an aggravated felony for immigration purposes. The same with subsection G, a theft including receipt of stolen property offense for which imprisonment is at least a year. And if 64-day sentence here, it's not going to be an aggravated felony offense. When we scroll down farther, definition, are some sections of the aggravated felony where the minimum be important as well as minimum. Under section Q, offense relating to appear by for service of the sentence underlying is punishable for a term of 5 years or more. So there's no actual term of that's required. You have to look to what is the underlying offense, and whether that offense was punishable by 5 years or more. Does that make sense? Okay. Another part that quickly is oftentimes criminal defense attorneys ask, well, what if I just pleaded down? And let's say it's an attempted obstruction of justice, because obstruction of justice here is an offense to obstruction, perjury, subordination of perjury of a witness. Imprisonment is at least 1 year. Section 1 year. But if I pleaded attempt, if we down here under subsection U, an attempt or conspiracy to commit an offense described in this paragraph, at times you may end up with an aggravated felony conviction. For example, attempted delivery of cocaine is going to be an aggravated felony under the terms if the State Controlled Substances Act matches exactly or is under inclusive of the federal controlled substance offense list.
So they're a step ahead of us in that regard.
So again, this is a little complicated, but you have to actually read the statute. You need to start with the statute. And again, the Immigration Nationality Act statute is available on the internet if you don't have a copy in your office. So one might note particular slide, we want to see what the actual sentence is on, as we point provisions that require an actual sentence to be imposed, incarceration imposed, and it doesn't matter how time is actually served. It's what is imposed or hung over the person's head. So moving along to the crimes involving turpitude, we have the ground of deportability and then we have the ground of inadmissibility. And these two grounds, I want to go back to the actual sections of the code that are available to us because it requires looking at the language of
both. So Maria, deportable crime of
okay. Paula, someone is deported for moral turpitude. We're going to look at 8 section 7A. So it becomes important to have screened out beforehand whether it was actually admitted to the United States, whether they were inspected or admitted to the U.S. So an alien convicted of a crime involving moral turpitude admitted within 5 years after the date of admission. So we need to know, one, what's the commission of the offense, and important is considered to be the person's date of admission to us, and there is convicted of a crime of 1 year or longer may be imposed. So we need to look and see what is the maximum possible penalty for the offense. The ground of deportability for a crime involving turpitude, an alien who at any time after admission, so again, when was the person admitted as a convicted, and it has to be for 2 or more crimes involving moral turpitude, not out of a single scheme of criminal misconduct. That is going to render them deportable. So within the 7th year, let's let's take a quick look. The maximum possible punishment for a misdemeanor offense in Illinois, Indiana, Wisconsin. So the maximum possible over in Illinois is 364 days. In Indiana, it's 365, and in Wisconsin, it's 9 months. So where we have a permanent resident who was admitted to the U.S. and within the 5-year period after the date of admission, they are convicted of what is deemed to be a crime involving moral turpitude as a Class A misdemeanor in Indiana, they're going to be deportable. Now, the same offense over in Illinois and the same time frame is not going to render this person to be deportable.
And clearly there was no intent in Indiana to make that crime a more serious offense. I mean, we're talking about how a year is defined in essence.
Correct. We are. And there have been some states, for example, that have now changed their definition of a misdemeanor to reduce it to 364 days or less. For example, the state of Washington changed its law, and a misdemeanor in Washington is now defined as 364 days instead of 365 days. And while I understand there have been some efforts made here in Indiana to try to change the date from 365 to 364, to date that has not been successful.
That's right.
On the grounds of inadmissibility, let's take a look at that section as well. Because here we have two different things. One is called the juvenile offense exception, and one is called the petty offense exception. So in looking at the statutory language under 8 U.S.C. 1182, A2A double I, capital I, or big I, the ground of inadmissibility for a crime involving moral turpitude shall not apply to an alien who committed only one crime. So you can only have one crime involving moral turpitude if either first, the crime was committed when the alien was under the age of 18. So we need to know how old the person was on the date of the commission of the offense, and the crime was committed and the alien released from any confinement to prison or a correctional institution imposed for the crime more than 5 years before the date of application for a visa or other documentation and the date of application for admission to the U.S. This is known as the juvenile offense exception, and it does work. For example, if you have a 16-year-old who is charged up in adult court and he is convicted of, say, felony retail theft, and he is now eligible to apply for adjustment of status based on a parent's petition. And even though he was sentenced to serve, say, a year in the county jail, he's now age 23. So his application is going to be more than 5 years after the date he was released from jail. So he served and got out when he was 17. And now he's 23, so it's more than 5 years before. So the juvenile offense exception is actually going to apply to him. So this is kind of unique. So again, we need to know the date of commission, age on the date of commission, and the amount of time that has passed. Now, the second prong, which is actually more common for many non-citizens, is known as the petty offense exception. And this is where the maximum penalty possible for the crime of which the alien was convicted, or the alien admits having committed, or of the acts that the alien admits having committed constituted the essential elements, did not exceed imprisonment for 1 year. And if the alien was convicted of such crime, the alien was not sentenced to a term of imprisonment in excess of 6 months, regardless of the extent to which the sentence was ultimately executed. That's a lot to think about. So one is we have to look at what is the maximum penalty possible. So under the Indiana Code, the maximum penalty possible for a misdemeanor is 365 days. So what's going to make the difference here? The difference is going to be the maximum term of imprisonment or the maximum jail sentence that is hung over that non-citizen's head has to be 180 days or less. If the person, the maximum sentence, or, I'm sorry, the sentence actually imposed on the non-citizen is your typical 365-day jail sentence that's suspended pending completion of probation, this conviction is not going to fall within the petty offense exception. And so say the permanent resident who travels abroad and then comes back in with a 365-day jail sentence hung over their head for a crime involving moral turpitude, they're going to be deemed to be inadmissible to the United States. And as we discussed earlier, that person is also going to be subject to mandatory detention upon return to the United States and subjected to removal proceedings unless the conviction was entered prior to 1996's change in the law under the Vartelis case that we discussed earlier.
But so my understanding, though, is that if the person doesn't leave the U.S., this doesn't come into play. Is that correct?
Well, that would be correct if the crime was committed more than 5 years after the date of admission. So let's go back in our permanent resident case again, and let's just take a quick look back here at the definition of the ground of deportability for crimes involving moral turpitude. So again, under 8 U.S.C. 1227 A2A small I, is the person is convicted of a crime involving moral turpitude committed within 5 years after the date of admission and is convicted of a crime for which a sentence of 1 year or longer may be imposed. So an Indiana misdemeanor for someone who is recently admitted as a permanent resident or, for example, as a student will be found to be deportable for that conviction.
Okay.
But you've asked a very good question. Now, a conviction has to be final in order for there to constitute a ground of ability. And while some of the circuits have done away with this finality requirement, in practice, if a conviction is on a direct appeal, then immigration court in Chicago at least will consider it not to be a final conviction with to distinguish the Seventh Circuit Montenegro versus Ashcroft here on the presentation.
Okay, here's a hypothetical. Marco is arrested and charged with 1 count of domestic battery, a Class A misdemeanor. He pleads guilty to domestic battery causing bodily injury. The court orders 365 days in the count with 180 days executed and 180 days suspended for the 65 days. Completion of an alcohol and classes and of a $2,000 fine. As Marco convicted for purposes of AC 11A48?
Well, Paula, in this case, he has been convicted. So the formal judgment of guilt has been entered. And even if it weren't, if this was a deferred adjudication or an adjudication under prong 2 of 8 U.S.C. 1101A, he actually pled guilty and the court punishment to be imposed.
Okay. What is the sentence that counts for immigration purposes?
Well, the sentence that counts 365 days imposed in the county jail. So he's only going to 180 days of that, and the rest is going to be suspended pending completion of probation. That 305 days sentence is going to be what counts.
And what are the possible immigration consequences for Marco?
Well, here we are going to look at this potential crime of violence as an aggravated felony under AC 1101A43F. So it's potentially an aggravated felony because he pled guilty to domestic battery causing bodily injury. Now, if this had been a domestic battery provision where it was an insulting or provoking, it would not be. And there's a case that arose out of India, the Seventh Circuit issued called Flores versus Ashcroft, in which the court goes back and forth about dynes of forces used and spitballs and snowballs versus what he did, which was punched his wife in the face. And in the end, because the touching in Indiana required a minimal touching without causing bodily injury, it was held not to be a crime and therefore not a crime of domestic violence.
And then what do you think that you need to know?
Well, I know one, whether or not had actually been in the United States, whether he had been inspected and deported. Because, as we saw with the grounds of deportability, it's any alien who has been convicted of domestic violence after extradition. So that's a critical point. I would also want to know the statute to which he pled, because I need to look at the elements of the jury instructions and law. Now, another thing just to remind folks of here in Indiana is you have to look at what the requirements are to get into a diversion type program or to defer application of guilt or the actual entry of guilt into the record. And it seems to be county by in Indiana. So look into it carefully. So other convictions out of other states will matter. And so you need to know what the requirements are. And I found that often calling up a public defender or calling the county court clerk will get me an answer, or at least where I need to look for what was the program at the time. Okay, and as we discussed, we need to note the definition of conviction, whether the two prongs for the withholding of adjudication of guilt are met. Under a case called Matter of Punu, deferred adjudication conviction, even if sentencing is withheld or charges are dropped at a later date. So in this particular where the person pled guilty and then was ordered to be sent to pay some fines, and then later at the end of it was deemed to be dismissed, it still constituted a conviction. And because Indiana is next door, let's just look really quickly at a statutory provision over in Illinois. There was something called supervision. And so if you get supervision for a first offense, if you qualify for supervision, you have to plead guilty, and then the court orders you not to commit any other offenses and to comply with all law. If you violate your supervision, then the prosecutor can move forward with actually asking the court to enter judgment of guilt. If, however, you complete supervision, then Illinois law, you are deemed not to have a conviction. Well, for non-citizens, a supervision on a domestic battery offense is still going to be deemed to be a conviction if the domestic battery subsection to which they pled was the one that involved bodily, because causation includes the use of force for that.
Okay, here's an hypothetical. Janish was arrested and charged with theft under prior Indiana code for stealing $50 of gasoline from a stop. His defendant negotiates a pretrial diversion to one count of Class A conversion in court, which requires to plead guilty and then complete the hours of community service, which the court will dismiss. Has been convicted for under 8 U.S. 101A4.
Yes, he has. So this is a pretrial diversion. He pled guilty. He was ordered to complete community service.
been imposed of immigration law?
A sentence service has been imposed, but as far as a sentence to imprisonment, no, there has been a term of imprisonment ordered in this case.
And then the important question, are there any immigration consequences for Janusz?
Well, yes, there are going to be immigration consequences here. So again, let's take a couple of scenarios. Let's say Janusz is a lawful permanent resident, felony theft. So we would want to know what was the date of admission of Janusz, whether it was originally as an immigrant or whether he entered on a tourist visa stayed. If he entered on a tourist visa, overstayed, and then got his green card within the U.S., it's actually going to be the date of his entry as a tourist that is going to count. So if he is undocumented, meaning he came in illegally to the United States, then to look at whether or not he's eligible for any immigration benefits through or through a 21 or older citizen child. As one other interesting aspect of this case is, let's say he is a permanent resident and he committed this offense in 2014 before the law changed in Indiana, and he wants now to apply for citizenship. Is he going to be barred from applying for citizenship for a Class A conversion offense? Well, that gets us into another issue which involves good moral character and the period which you have to demonstrate good moral character, which is going to be 5 years because Janusz is married to a U.S. citizen. So he demonstrated good moral character for the last 5 years. Well, under this particular scenario, Class A conversion, plea of guilty, no jail imposed. Under the definition of good moral character at 8 U.S.C. 1101 FS, he's going to fall under the petty exception. So because he will not be deemed to be inadmissible or inadmissible crime involving moral turpitude, because the maximum possible was 360 days in jail, and what was imposed is no jail time. So he actually will qualify for admission.
Okay. We have Robert, who was charged with one count of Class A conversion, stealing $50 of batteries from Walmart. The prosecutor offers to have Robert plead guilty to the offense and then request the court to continue the case if Robert signs in with the prosecutor to complete 200 hours of community service. Has Robert been convicted of the statute?
Well, in this particular case, if agreement with the prosecutor is not placed into the court file, I would say he has not been convicted of under the definition of a conviction. If it sign that goes into the prosecutor's file, it's not part of the record of conviction, and you don't have or punishment, penalty, or restraint on liberty.
The sentence been imposed for purposes of immigration law?
A sentence has not been imposed with respect to a term of because there is no imprisonment ordered.
And finally, immigration consequences for Robert.
In this particular case, again, we need to know what is status. Was he admitted to the U.S.? What was admission? And whether or not that agreement court file or not. The court's going to form him. Okay, so sometimes state laws that you can have a first offender type provision, especially with respect to drug offenses. And so the Federal First Offender Act under SC Section 3607A only covers drug offenses, and it covers federal drug offenses for states outside of the Ninth Circuit's jurisdiction. And as we're going to talk about, there's an effective date from a decision in the Ninth Circuit as well regarding similar state level first offender provisions. Now, under a case called Matter of Roldan from the Board of Immigration Appeals in 1999, where a state action takes place to expunge, dismiss, cancel, vacate, or discharge, or otherwise remove a guilty plea based on a state rehabilitative statute, the non-citizen is still going to actually be deemed to be convicted for immigration purposes. So just like we talked about the Illinois provision granting the opportunity to get supervision, which is not going to be deemed to be a conviction for Illinois purposes, but it is going to be deemed to be a conviction for immigration purposes. So the circuit in 2000 had issued a called Lujan Armendariz, which addressed state rehabilitative statutes that were similar to the First Offender Act. And the board said initially it was only going to follow the state equivalents to the First Offender Act within the jurisdiction of the Ninth Circuit. Well, the Ninth Circuit, 11 years later, reversed its position, but held the effective date was going to be the date of the decision going forward for purposes of the first offender provisions.
Okay, our next hypothetical. Mikhail is arrested and charged with possession of 15 grams of marijuana. The court agrees to continue the case in order for Mikhail to complete drugs as part of the county's drug program. Has Mikhail been under 8 U.S.C. 1101A48?
Well, Paula, we're going to really need to delve into what are the requirements of the county to get the first offender drug program. So, for example, where I practiced in Illinois, in Cook County court continue a case without requiring a plea of guilty and tell the person that they are going to go to drug school and complete drug school, and if they successfully complete drug school, the case will be dismissed. This program does not result in a conviction for the non-citizen. However, the next county over to the west, Kane County, requires that the person plead guilty and then the judge orders them to drug school. So in the Kane County program, the non-citizen has a conviction for immigration purposes. Are there any immigration consequences? Well, if Mikhail holds a green card and he pleads guilty, does drug school, and then decides to take a trip to Russia because his grandfather is dying, when he comes back to the U.S., he's going to be deemed to be inadmissible for possession of 15 grams of marijuana because it falls under the grounds of inadmissibility under 8 U.S.C. 1182 A2A II. If, however, Mikhail doesn't leave the country, permanent resident, he can actually apply for citizenship if he is eligible to do so. Why? Because this is an exception of deportability. So there's a specific exception in the ground for possession of 30 grams or marijuana. Now, if Mikhail is applying for a green card marriage to a U.S. citizen and he admits to the possession of the cocaine, pleads guilty to get into the first offender program or the drug school program, and the court will go to drug school or do other requirements, he is going to be inadmissible. Would need a waiver under a section of law called 8 U.S.C. 1182H in order to be able to adjust his status and get Okay, so another area that comes up here that is often raised is juvenile delinquency adjudications. So with respect to delinquency, they are not going to be deemed to be a conviction for immigration purposes, with a few exceptions, which involve drug trafficking and prostitution and crimes of violence for people who are applying for adjustment of status under the Family Unity Act. And this is a provision from back in the early 90s. Okay. Another note, just quickly, on delinquency adjudications. Indiana does have this extended jurisdiction statute, as does Illinois, and there is no clear case law on that. Extended juvenile jurisdiction proceeding, the juvenile pleading guilty to having committed the offense, they're adjudicated delinquent, given an adult sentence to a term of imprisonment. So as of right now today, we don't have a clear decision on this provision. We also have that provision next door in Illinois. Okay, court-martials seem to be a conviction for immigration purposes, as we can see. Okay, so we've been talking a lot about the definition of admission. Where do we find it? It's under 8 U.S.C. 1101 A13. So the terms admission and admitted mean, with respect to a lawful entry of the alien in the U.S. after inspection and authorization by an immigration officer. Well, that seems really straightforward. But for purposes of screening out your clients, to very carefully on how they entered the United States. And I say there is case law on the Board of Immigration Appeals, which is still good case law, says that if the person entered and was inspected by seat of a car at the U.S.-Mexico border or the U.S.-Canadian border, then, and the person was reviewed by the officer and then waived through border crossing, they technically were inspected and admitted. And that is going to make a difference in what the imminent consequence will be with respect to relief from removal or eligibility for any immigration benefits within the United States. So that's a practical point for you to consider. Question your client carefully about how they came into the U.S. Then we have this issue role for crewmen. We talked about a little bit earlier about permanent residents being deemed admissible if they leave the country after committing or being convicted of certain offenses, including a small amount of marijuana. Well, the definition of admission can apply to a permanent resident. So under 1101 A13C, lawfully admitted for permanent residence in the United States shall not be regarded as admission into the United States for purposes of immigration laws unless the alien, 1, has abandoned or relinquished that status, 2, has been from the United States for a continuous period in excess of 180 days, so 6 months out, 3, has engaged in legal activity after having departed the United States, 4, departed from the U.S. while under legal process seeking removal of the alien from the United States, including removal proceedings under this chapter and proceedings. So basically what this means is that if you're in removal proceedings as a person, you really should not be traveling outside of the United States. Or 5, committed an offense identified under 8 U.S.C. A 2, which again, just as a quick reminder, includes the possession of a small amount of marijuana, crimes involving moral turpitude, 5 years or more sentence for all crimes committed, prostitution, money laundering, and some others. Unless, since the alien has been granted relief under 8 U.S.C. 1182 or 8 U.S.C. 29BA. So the 8 U.S.C. 1182A is a waiver available for 1, possession of marijuana of 30 grams or less, or drug paraphernalia related to possession of marijuana of 30 grams, or a crime involving moral turpitude or prostitution. And 8 U.S.C. 29, as close parentheses, relates to something called permanent resident cancellation. Even though it doesn't state this here, it also means 212C relief for people who are granted 212C waiver. So And then the last one is 6 to place their time other than as designated by immigration officers or has not been admitted to the States after inspection and authorization by an immigration officer. So under the subsection 5, if we go back to the example of Mikhail, and he's a permanent resident, and he gets convicted for simple possession of 15 grams of marijuana, leaves the U.S. and comes back in, he is going to be considered to be an arriving alien and to be inadmissible and seeking admission. So if you have a permanent resident client or someone who is a student or is here on one of those other temporary non-immigrant visas, or a refugee or an asylee, you really should put in writing to the client after they've been convicted, if you can't work something out, that they cannot leave the United States. And this will cover you as the attorney for the conviction.
We have some more hypotheticals regarding the definition of admission. Edward entered with a B2 visa at O'Hare International Airport. Has he been admitted?
Yes, he has. He was inspected and admitted by a CBP officer.
Okay. Mark entered the U.S. at BWI Airport as a... Was she admitted?
Yes. She was inspected and admitted.
Juan swam the Rio Grande in 1980. He then adjusted status in 2000 at the Indianapolis INS office. Juan been admitted?
Yes, he has, for purposes of deportability, for being convicted of any of the grounds of deportability. So he was inspected by an officer and granted adjustment of status, so he has been admitted in 2000.
Okay, I was going to ask his date then. Would date 2000? Sylvia rode in the back seat of a car through the Detroit-Windsor border. The driver was questioned by CBP agents. Was Sylvia admitted to the U.S.?
Well, Sylvia was sitting in the back seat of the car and the officers could see her, then yes, she did. If, on the other hand, Sylvia was crouched on the back seat of the floor and a blanket was over, then no, she was not technically.
The U.S. as an immigrant, lawful permanent resident in 1995. He was arrested in 2001 and charged with possession of 10 grams of marijuana. He pled guilty and was sentenced to 6 months of probation, which he completed in 2000. In 2015, Mikhail left the U.S. for his mother's funeral in Russia. In the U.S., will he be deemed to be seeking admission as a returning lawful resident?
Yes, he will be, because his conviction was after 1996, and the ground of inadmissibility exists for a small amount of marijuana.
And what are the consequences of his guilty plea?
Well, in this situation, because he would be deemed to be inadmissible when he returns to the United States, he is subject to mandatory detention under 8 U.S.C. 1226C. He can request that he be paroled to the U.S., and that is up to the discretion of the CBP officers, whether he will be paroled instead of being detained to undergo a deportation or removal proceeding, as I'll call it.
Okay, and can he apply to become a U.S. citizen?
Yes, he will be eligible to apply for U.S. citizenship only after his removal are decided by the judge. Now, based on this set of, he's actually eligible for some lawful permanent resident cancellation of removal, in which an immigration judge wants all the good and the bad, or basically the positive equities and the negative in his case, to determine whether he can maintain his permanent resident status. He would also potentially be up for some 212H waiver, and that would depend on whether he has a qualifying relative, being a U.S. citizen, resident, spouse, parent, or child, to whom he can show extreme hardship if he were. And there is a bit of a difference as far as the definition of conviction applies to the inadmissibility. So under 8 U.S.C. 1182A2, a formal is not required to render the inadmissible. Alien has been convicted, admits having committed, admits committing, which constitute the elements of a crime involving moral turpitude or a controlled substance violation as the controlled substance is defined under C 802, or any violation of the law relating to the controlled substance. We talked already about exceptions for crimes involving turpitude being the juvenile offense exception and the petty exception. The other grounds of inadmissibility, which are important, include this ground where you have multiple convictions, where the aggregate sentences to terms of confinement imposed was 5 years or more. This is a provision called the line them up and add them up. So you take all the dispositions, you lay them down by side, add up the amount of time of confinement or jail time that hung over your client's head. Here in Indiana, when we've got our driving without a license, it's easy for quickly rack up more than, say, 4 to 5 years confinement that has been ordered. So that is one thing I would encourage you to take note of. You definitely have to inquire of your clients about any other arrests, including traffic violations out of states, because this can also bring up a particular ground of inadmissibility. Now, one thing to note is that even though we have a deportability firearms offense, there is no ground of inadmissibility for a pure possession firearm offense. However, a firearm offense may be deemed to be a crime of moral turpitude, say where it is a battery or an assault with a firearm. If it's a crime of moral turpitude, that will then constitute of inadmissibility. Okay. Now, there are some grounds of inadmissibility where there is no conviction required at all. So there is one for the controlled substance trafficking, which requires that the Attorney General have a reason to believe the person has been involved in controlled substance trafficking. So, for example, you have a permanent resident who was originally charged with possession of cocaine with intent to deliver cocaine, and that gets pled out to something else, and reports indicate that the person was with possession with intent to deliver, then your client really should not be outside the U.S. because they can be deemed inadmissible upon their return. So how could they arrive? Well, before a flight comes back to the United States, the airline have to forward the passenger manifest to Department of Homeland Security, which then runs a background check on all the passenger names. And when the person is the agent in line at the airport to be screened through, then there will be a red alert in the system. A permanent resident will be pulled off the line and sent to secondary inspection to be further questioned. There is no right to counsel in second inspection. So unlike you have a right to counsel when you're arrested for a criminal offense within the United States, there is no such right at this time for a non-citizen who is put in secondary inspection. There are efforts to try to change that. The person also does not have to be convicted and been involved in prostitution within 10 years of date of invitation, a visa, or adjustment of status. And we will note that prostitution is legal in the state of Nevada. It's also legal in some other countries. So this is another issue to screen out for. Commercialized vice, security grounds, which are listed here, and smuggling of aliens. So when question potential, I ask them, who did you enter the United States with? Did you want to swim the land? Did you give a hand in the middle of the river? Did you drive the car across the border? Who was in the car? These are all issues for which person does not need to actually be convicted to be found inadmissible. Okay, and we talked about grounds of deportability for crimes involving moral turpitude. Now, what is involving moral turpitude? Well, let's talk about this for just a moment. In Jordan versus George in 1950, the U.S. Supreme Court held that the term crime involving moral turpitude was is not void of vagueness. In general, crimes involving moral turpitude have been defined as being crimes where the offense is depraved, vile, or contrary to the mores of society. So there's been a lot of change in the law. Before the first Matter of Silva Trevino case was published by the Attorney General in 2008, the basic test had been you look at the elements of the statute and you're limited to the elements of the statute categorical approach. And you only got to look at the criminal offense in the indictment, the complaint, or the information if it was a divisible statute. Figure out what statutory section the person had actually pled guilty to. In 2008, the Attorney General held that the immigration court and immigration adjudicators could go beyond the record of to determine what the individual actually did and to consider record evidence. So all the circuits overturned the Attorney General's 2008 decision except for the Seventh. And after a lot of advocacy and court challenges, and this issue going up to the U.S. Supreme Court, particularly in light of the Supreme Court decisions we saw here in the presentation, discussing the strict categorical approach and when a statute's divisible. In 2015, earlier this year, Attorney General Holder vacated the 2008 decision and ordered the Board of Immigration Appeals to issue a new precedent decision. And the issues that are presently pending before the Board of Immigration Appeals is one, how adjudicators are to determine whether a particular criminal offense is a crime involving moral turpitude under the Immigration Act. So basically saying, what is the test? And two, to what extent adjudicators may use a modified categorical approach and consider the question to determine whether the alien has been convicted of a crime involving moral turpitude in applying 8 U.S.C. Section 1182A of the Act and similar provisions. So, at the very beginning of this case, it's really important to be up to date on the case is at the time right before your client pleads guilty. As we've seen here, there have been a lot of changes by the Supreme Court and the Attorney General on the Board of Immigration Appeals as to how the Immigration Act is to to non-citizens involved in criminal activity or have been convicted of criminal offenses. Okay, the term aggravated felony, you're committed the offense time after admission. So again, this admission issue kicks in here. And as we can see here, the definition was created in November 1988 through the Anti-Drug Abuse Act of 1998, and it included only murder, trafficking of drugs, and weapons. That's pretty based on what we think is an aggravated felony. It was amended in 1990, expanded to crimes, amended in 94 for RICO crimes, and then the biggest 30th of 1996 to include more than 50 categories of crimes and retroactively. But in the Seventh Circuit, it does not apply to convictions that were before 1988. The anti-drug abuse was enacted. So as we saw, to go from drug trafficking and weapon trafficking to
over 50 categories.
And we talked about earlier, which is an Indiana conviction for conversion with a 1-year sentence imposed. So there seems to be a rather draconian impact on a very really minor misdemeanor offense, just based on the 365 for a conversion offense. High-speed flight from an immigration controlled offense committed at any time after admission. We've got our one in here for possession of 30 grams of marijuana or the drug paraphernalia related to 30 possession grams or less of marijuana. And then Butsy, Malooly versus Lynch. This goes back to our reminder that you have to compare the schedule of controlled substances in effect at the time of commission of the offense with of controls in effect at the time of the offense. Also deportable firearms offenses, miscellaneous crimes, and domestic violence, child abuse, abandonment, or child neglect. Grounds of deportability where no conviction is required if you have been or are a drug abuser or drug addict, failing to register a change of address, marriage fraud, aliens, one exception, family reunification, failure to maintain your non-immigrant status, you're here without permission, security grounds expected, and national security threats and terrorist activity. Okay, a quick word on conviction relief and others. Then we also talk about sentencing modification. We'll cover presidential pardons, sealing ups, and expungements. Okay, under Pickering, if a conviction is vacated for reasons that are solely related to rehabilitation or consequences instead of being a procedural or substantive effect in the underlying criminal proceedings, then the conviction is not eliminated immigration. So where you have a motion for post-conviction relief or for post-conviction relief needs to be grounded in a substantive defect in the underlying criminal proceedings or on a constitutional violation. If it's not, then the Immigration Service does not have to respect the vacatur. So federal law trumps law. So those state rehabilitative statutes trumped by the of conviction under the federal statute. Okay. Now, failure of the state court to advise immigration consequences of a can be the basis for the vacatur if you have a state division, state Supreme Court rule that mandates that the trial court advise immigration consequences. Okay. So over in Indiana and Wisconsin, there is such a rule in Illinois and Wisconsin, there's a rule in effect. And here in Illinois, we have that yet?
In Indiana, no.
No.
Not yet.
Not yet. Okay, so that's the area.
It needs to be changed.
So why would you think? Well, because a person should really understand what the consequences of that plea before they enter the plea or decide to go to a jury trial. So Wisconsin and Illinois actually have state statutes on the books requiring the trial court to advise. So, but again, that doesn't, even in those states, eliminate the mandatory, the defense attorney to advise early. Okay. Talked about the ineffective assistance of counsel grounds. Okay. So it's critical, get your pleadings and get all your hearing transcripts and make them part of your for post-conviction, because the immigration judge is going to look at what was included in that petition post-conviction relief and to see what's grounded in a substantive effect. All right, now sentence modifications are another completely different game, and a sentence modification can take place for purposes, and in this context, it will be respected by the immigration judge. Excuse me. So when we spoke earlier about the 365-day sentence being imposed on a conversion, an aggravated felony, if there's a post-conviction motion to resentence and knock 1 day off to 365, that person is no longer deemed to be an aggravated felon for purposes of law. It has to be full and unconditional. It can only pardon state crimes. Presidents can only pardon federal crimes. What does it cure? Well, a full and unconditional pardon will eliminate the ground of ability for crimes involving moral turpitude, felonies, and high-speed flight. With respect to the aggravated felony ground, let's say someone's been of drug trafficking and it does constitute an aggravated. That person is deportable for an aggravated felony and also deportable for having been convicted of a offense. So the pardon will eliminate the aggravated felony, but the person will still be deportable for the controlled substance offense, but then may be eligible for relief.
Okay.
Okay. Don't do it. Killings and expungements.
Yes, Extreme has come late to Indiana, but what can you tell us about it?
Well, for expungements, generally expunge a conviction. It does not eliminate it for immigration purposes. And people for immigration benefits will end up having to go back and get that record unsealed, prove what happened with the.
Okay.
So this has come up in
So it
removal
actually
proceedings.
creates a problem. Not only does it not cure the situation, it creates a problem.
Does create a problem. Now, the one exception has been for DACA eligible applicants. It's a little ironic, but there's actually a practice advisory on this for non-citizens.
When you say advisory, what do you mean?
The Internet Immigrant Legal Resource Center has a practice advisory on expungements for DACA. Okay, and we're going to run through some of those resources coming up. Okay. Forms of relief from removal. There are different relief that the person may still be eligible or barred from, depending on the outcome of the criminal case. Adjustment of status with or without a waiver, permanent resident cancellation if it's an offense, a 212C waiver, 10-year cancellation of removal, spouse or child cancellation of removal, and voluntary departure, asylum withholding of removal, which is the probability of persecution, relief under the Convention Against Torture, a really old form called registry, if the person came before 1972. And then for certain people from Nicaragua and Cuba, we have NICARA cancellation or suspension, temporary protected status, U visas, T visas, S visas. So if your client wants to flip and work with law enforcement, there's an S visa or an informant or snitch visa, as it's known. And then VAWA-based self-immigrant visa petitions and adjustment of status. We also have something called deferred action status, private bills through Congress, pardons may affect, prosecutorial discretion, and deferred action or DACA. And the disqualifying, and we went through the website earlier. Okay, so the forms of relief can be an entirely separate webinar. It's a little complicated. So why do we want to still consider this? Let's look at the big picture. In the end of the day, people who get put into a criminal proceeding are often still seeking justice. And so how do we look at this? We look at fundamental fairness, constitutional rights, statutory rights, and the impact on families and the community as well. So we spoke about the Malooly case earlier. It's not just people who are here undocumented, but a math professor got deported on the possession of the sock. As a defense attorney, it's really important to sit down with your non-citizen client and what are the goals of your non-citizen client? Is it to stay in the U.S., family, community, and employer? Is it to have the opportunity to for relief? Is it to be able to still go to the consulate abroad and ask the immigrant visa to be granted? Or is it just I want to get out of jail as quickly as I can and get deported? If the person has absolute possibility to remain in the U.S. and has no desire to remain in the U.S. Is it that they want and need drug treatment? You know, Indiana just recently has enacted some new provisions, Paula, right?
Right. Mental health and abuse treatment. Right.
Is it that they need some driving, some counseling potentially? Permanent residents avoid the aggravated felony conviction. Possible at all. And then if the prosecutor wants to charge to a sentence that doesn't render the person not to be convicted of an aggravated felony, then your client may actually just take the case to trial. It's their right to want a penalty, or do they want to go to trial and roll the dice? You've got a prior conviction that is currently, they're facing a new charge, then a motion to reduce sentence may render it not to be an felony if it's based on the amount imposed? Or is there a possibility of a motion to vacate? Is there new evidence to suggest the person was actually innocent if they trial come forward with new evidence? Ways to go back and vacate. Other possibilities that don't carry the immigration consequences, but that will still prosecute the amount of time that he or she is seeking in jail, or increased community service. Other types of punishment will not render the person either liable or barred from all forms. Ask that be continued and allow the non to necessary to either get the case dismissed or to get a charge. Again, you have to be current and up to speed on the relevant decisions. Seventh Circuit, Supreme Court, Board of Immigration Appeals, really important. On domestic cases, the relationship of the victim and the record of conviction is going to be critical, and here are some suggestions. Request a dismissal and filing of a new complaint to a charge which is not domestic battery. Request a continuance so that the person can get counseling, substance abuse treatment, alcohol abuse treatment, job retraining, whatever it may be, particularly where the victim does not want the non-citizen to be deported. Keep the U.S. citizens off the welfare rolls if the main provider of income to the family is no longer going to be in the picture. So we have some resources that are common ones. As we see, you can Google and quickly obtain the current version of the Immigration and Nationality Act. The regulations are contained in 8 CFR 101. And then there's a very useful book, which is a resource book called Kurzban's Law Source Book. It's been cited in multiple decisions by the federal courts of appeals. We have the DACA and Practice Advisory. So the National Immigration Project and the Immigrant Legal Resource Center both have several practice advisories up about DACA eligibility, and particularly juveniles and criminal offenses. That may be useful to you. The Treatise Immigration Law and Crimes is a national treatise, which I do update, and it is updated twice a year. The proceeds go to the National Immigration Project. The Immigration Trial Handbook is a step-by-step, and it also has all the forms of relief and when someone is eligible for the forms of relief. We have Interpreter Releases, which is a weekly publication available on Westlaw and through subscription. The basic overviews of Padilla versus Kentucky are also available on Defending Immigrants' website, as well as the National Immigration Project's website. The Board of Immigration Appeals recently, just this year, in May, I believe it was, now posted an amicus invitation page. And this is really kind of a new thing, but it's also critical. And it's critical because it tells us now publicly what cases and what issues the board is looking at to issue a new binding precedent decision. So I'd like to take us just really quickly to the Board of Immigration Appeals website so we can see how the Executive Office for Immigration Review is at www.justice.gov/EOIR, and we have a lot of different links to resources. The one I want to point us to right now is the virtual library. And we're going to click on it. And you can obtain all the Attorney General and Board of Immigration decisions by year of the different volumes. So this is to decisions which and see them as did. On it, and let's give it a minute to look. So if we go to volume 26, for example, here's the Garcia decision, which is issued. We click on the link, and it will draw up December 2015. Access this, review it, to see how the board decided as it did. Here's the link here, amicus invitations. And so, I think, as I said, just went up earlier this year. Last updated November 10th of 2015. And we can see and what is being considered. We click on crime involving moral turpitude. The amicus invitation shows exactly what are the issues going to be reviewed. And as we know, Silva, the Attorney General's decision earlier this year, told the Board of Appeals to the test is going to be. So we can use another amicus invitation, and the line was the most recent one, and determine whether an offense is an aggravated felony under the fraud provision and whether statements must, quote, be material that the statute involves deceit. So we know that this subdivision one on which there's going to be a decision forthcoming. Mm-hmm. Within the same webpage, just really quickly, there's also a link to country conditions research. And if you're not familiar with a particular country from which your client comes, you can click on and get some quick links. So here we can click over to Mexico, a country that there's been a lot of violence in. You click on the tab for Mexico, and you have links now to Amnesty International reports, the U.S. State Department report, and it's a quick way for you to get up to speed on what the issues are in the countries. Not every country has an active link yet, but again, this is a quick reference for those of you that have clients from some of the countries that are more common.
So if you're like me, there's been a lot of information here and it's hard to keep track of everything, but Maria's going to help us out with red flags that we ought to all be able to recognize.
Okay, so this is just a really quick flags checklist that you may want to go ahead and incorporate in an intake questionnaire in your office. And if your office, being the Public Defender's Office, doesn't have an intake questionnaire, I highly recommend you create one so that you can document information about your client. And client is actually a U.S. citizen and requires the Padilla advisal. So some is, did your client enter without and doesn't have a green card currently? Did your client get their green card 5 years ago and they resided in the U.S. for less than 7 years ago? Were they ever arrested in the past by INS or the Department of Homeland Security or anybody along either border? We've had Canadians who have entered illegally. So it doesn't mean just Mexicans or people in South America or Central. All clients need to be asked if they have any priors for anything in any other state or jurisdiction, including traffic. Look at the traffic offenses. Prior DUIs are at the top of the list right now. Issues involving grounds of trying to remove some of the 2014 memo that came out by Jay Johnson 2014 and who is a priority enforcement. If there's any prior arrest for anything involving sexual contact or conduct, that is important to screen. Prior controlled substances, including drug paraphernalia, even if it was under a city, sometimes the city ordinances actually refer back to our state criminal codes and incorporates the state criminal codes. Anything involving domestic assault, domestic battery, and orders for protection are really critical. And if they're charging potential charges for controlled substance violations, crimes involving moral turpitude, criminal conduct, assault, offenses against children, prostitution, DUIs, firearms, juvenile controlled substance and prostitution or crime of violence in delinquency J proceedings or the juvenile prosecution as an for any of the above listed offenses. Those would be things to really screen for. So this has been a lot of information. Hopefully you'll be able to take it and start to use it in your own practices going forward and accurately advising your non-citizen clients.
Thank you so much, Maria, and thank you, those of you who are watching this. We are done.